Welcome to the Political Philosophy Podcast. I'm Toby Buckle. You really can't understand American politics without understanding the role of the Supreme Court. Why, for instance, is abortion illegal in half of the states but legal in the other half? What's up with all the money in politics? Wait, Trump is now suddenly immune from prosecution? What's going on with that? All of these are questions to which you have to understand the role of the American judicial system. And I've touched on it plenty in the podcast, yet for whatever reason I've never done just an episode on the Supreme Court. This is that episode. My guest today is Professor Noah Rosenblum. He's an Associate Professor of Law at New York University School of Law and Faculty Director of the Vanderbilt Scholars Program. He's also a faculty affiliate of the Department of History. Noah works primarily in administrative law, constitutional law and legal history, and his research takes a historical approach to the study of state institutions, seeking to understand how law can be used to promote democratic accountability. It was a real pleasure to sit down with Noah and chat about how we should see the court in general, how it has increased its power in recent decades, and what we should expect going forward. I don't think the conversation needs much more introduction than that. I think generally people get how important this institution is and how increasingly important it has become. So aside from a quick note that if you like these episodes, please do sponsor me on Patreon, patreon.com/political philosophy podcast. patreon.com/political philosophy podcast. Let's get straight to it. This is the Supreme Court with Noah Rosenblum. I am joined today by Noah Rosenblum. Noah, thanks so much for coming on the podcast.
Thank you for having me, Toby.
So I wanted to do the Supreme Court today. Just to start with, let me ask a really basic question. In the simplest possible terms, what is the Supreme Court?
The Supreme Court is the only court required to be created under the Constitution. And so it's the apex court of the federal government, of the federal system.
That makes sense. What is the separation of powers? Take your time with that one if you need
to. Well, the fact that you ask it after the Supreme Court makes me want to talk about judicial supremacy and the relationship between the court's jurisdiction, which is dramatically underdefined, and why we think of the court in the context of separation of powers. I'm sure we'll get a chance to get into that. Because, of course, we could have separation of powers without ever having the Supreme Court. And in fact,
right.
Not to be super obnoxious history of political thought, but the idea
that's kind of what this podcast is. So, go nuts.
So our listeners will correct me, but my recollection is that we've got tons of theorists of separation of powers who identify different powers of government, but for whom the judicial power is not actually one of the core separate powers that you might want to separate out. So I would say the separation of powers is a principle of institutional design and maybe a tendency in the history of political thought that says something like, in order to ensure secure liberty, I guess that would be the Montesquieu framing, government should have the different powers that it exercises divided in some way. There should be a separation of powers inside the government. Okay, that would be like the political theory tendency, but you can correct me and tell me that I'm wrong about that. In law, in American law, separation of powers has a slightly different meaning, which is something like a principle that is occasionally embodied in judicial doctrine that says the design of the United States government involves separate powers that are housed in separate government institutions. And the doctrine of separation of powers, that is the judicial doctrine of separation of powers, the part of it that courts deal with, is a set of legal rules that courts enforce in order to vindicate that principle, make sure that government is in fact abiding by the commitment to separation of powers, the political principle.
In that schema, though, does the court appear both as one of the powers and as the arbiter of the dividing lines between them?
Yes, that's a great observation and question, and it cuts to what is so exciting and also infuriating about this field. So if we take off our political theory hats, put on our American lawyer hats, and in particular, buy into the ideology of judicial supremacy, then the court sees itself as the beneficiary of the principle of separation of powers. But by that, the court tends to mean only that it is independent of the other two branches of government. So a very simplistic understanding of the separation of powers would say that there are three powers in the United States, or three powers in the American government: the executive power, the legislative power, the judicial power. Each of these powers is vested in a separate institution. The executive power is vested in the president. The legislative power is vested in the House and Senate. The judicial power is vested in the judiciary, and that each of these people in whom the power is vested becomes its own branch. That branch is then responsible for exercising that power. So I want to complicate that picture later. I actually think that way of talking is very ideological, but that's a very standard way of talking about American law and government. The courts often buy into it, especially in this moment. Neil Gorsuch is probably the one who's been most aggressive about seeing the world that way. Under that vision, the court is the keeper of the judicial power, and because it's the keeper of the judicial power, it is also responsible for making sure that the rest of the government follows the law, including this commitment to separated powers. Now, even in this judicial supremacist, highly formalistic understanding of separation of powers, the court will recognize that some separation of powers questions are to be worked out by Congress and the president, that there are some that are not justiciable. They're not meant for judicial enforcement. So one example that always gets law students excited is that the American Constitution says the federal government shall guarantee a Republican form of government to all the states, which, putting our political theory hats back on, is very exciting, right? What on earth could that mean? But the Supreme Court has long held that that clause is not justiciable, that whether or not a state has a Republican form of government, which obviously raises interesting separation of powers questions, is really something to be worked out between that state, the Congress, and the president. The court is not to get involved. So that would be an example of a possible separation of powers principle, although maybe it's really more of a federalism principle. We can talk about that, but that the court doesn't get involved in. But this is a long roundabout answer to your observation. Sorry, no, I was just going to bring it back to your observation because it was just right on the money, Toby, which was to say, wait, isn't it weird that the court is simultaneously a separate power and has appointed itself the arbiter of separation of powers? And this is epitomized in the fact that the court will routinely say, well, this is a decision for one of the two political branches, by which it means the president or the legislature, as if the court isn't actually part of that very same schema.
You used the word ideology a few times there. So, for instance, the ideology of judicial supremacy, not the doctrine, not the principle. Why ideology?
Judicial supremacy is real because we believe in it, and we have created various institutions that rely on it. But the court wants to present judicial supremacy as if it necessarily follows from the Constitution, and as if it is established by the Constitution and by the law. But as everybody learns in constitutional law, there are lots of other approaches to thinking about what the law is. And the Constitution nowhere explicitly establishes judicial supremacy. And the cases that the court relies on for the principle of judicial supremacy are, of course, cases that the Supreme Court decided in which it anointed itself supreme. So I think that as a first sort of cut, the greatest champion of judicial supremacy has been the court itself, which is maybe not surprising. Whether we need judicial supremacy is a separate question. And I confess I feel a little uncomfortable talking about it at this very moment, where, as you may know, in the United States, there's a lot of debate about whether we're experiencing an auto golpe, whether the executive branch is currently trying to, well, really Donald Trump and his circle are trying to seize control of the government in violation of the law. And the courts are one of the few institutions that seems to be slowing down and pushing back against that attempt. And so this is a moment when I think a lot of people who are committed to the rule of law are also doubling down on judicial supremacy, totally understandably. But as a purely theoretical matter, there are reasons to think that American constitutionalism actually works better without judicial supremacy, and that there are some really fundamental questions of the separation of powers that probably shouldn't be settled in a final way by the courts. But of course, the courts and their commitment to judicial supremacy tend to resist that proposition.
So, just to clarify in the simplest terms, the amount of power that the Supreme Court currently has, the really decisive power it can wield, isn't necessarily something that's in the Constitution. It's a lot of the powers it has are things it has aggregated to itself over the course of its history.
Exactly right. And there's a lot of literature on the history of judicial review. So many scholars have argued that courts before the Supreme Court had already arrogated to themselves, in some circumstances, the power to strike down acts of the legislature in the name of the Constitution. There's, like I said, a big literature about this. Some people have disagreed and said that there are reasons why they're not exactly comparable. Certainly, the founders were familiar with the idea of judicial review, which is a form of judicial supremacy. Obviously not the only one, but one of the most dramatic, because it highlights a conflict between a law that would have been passed by the Congress and signed by the president on the one hand, and then the court's reading of the Constitution on the other. So when the court strikes a law down in the name of the Constitution, it really embodies that principle of judicial supremacy. The founders were familiar with that, and yet they did not include it explicitly in the Constitution. So that could be an argument for saying that the founders did not, as a matter of original intention, intend for there to be judicial review of legislation passed by Congress. Flip side, right? They didn't ban it either, and law professors have made very sophisticated, subtle arguments, both structural and textual, to show how the Constitution at least allows and maybe even implies or perhaps requires judicial review, despite not saying it. The way we tend to teach the history of judicial review and judicial supremacy along with it in constitutional law is by pointing to some famous cases in which the court announced that it had this power, and then to observe that for the most part, in fact, maybe even not just for the most part, maybe even just throughout American history, the other branches have recognized the court's power to do that. So the first case that people point to there, of course, is Marbury v. Madison, in which John Marshall famously concludes that the act under which the court would have granted Marbury his commission was unconstitutional, and so strikes it down. So that's the sort of first famous moment in which the court says we have this power of judicial review. Then there's a case much later, Cooper v. Aaron, from after Brown v. Board of Education, in which Southern states had resisted the court's order to desegregate, and the Supreme Court unanimously said that the states didn't have the power to do that, that the federal law was binding on them. It's worth pointing out, though, that of course, in Marbury v. Madison, had John Marshall ordered the president to give Madison his commission, it seems likely that the president would have just ignored his order. The president had, in fact, Thomas Jefferson and James Madison had resisted the idea that Marshall had authority to hear the case at all. And the Republicans in Congress, the party that Jefferson was a part of, had taken some pretty aggressive action against the Federalists, and especially the Federalists in court. So part of the reason why law professors are so excited about Marbury v. Madison and love to teach it is that even though it announces this major principle, it was also kind of the only thing Marshall could do to avoid being embarrassed, right? It's a bit of turning a loss into a win. So with his ruling, the government doesn't actually have to do anything. If it just keeps the status quo, it looks like it's complying with the court's decision that in fact the statute was unconstitutional and the court didn't have the power to grant a remedy. If we fast forward to Cooper v. Aaron, it's a very different story. But the enforcement of the court's desegregation orders come through the White House and famously Eisenhower's quite aggressive actions. But historians of American education will point out that in fact, Brown v. Board of Education doesn't lead to mass desegregation in the South. What does ultimately lead to desegregation in the South, such as we get it, is administrative action under various school funding bills and rules that get passed later. And obviously, Brown v. Board of Education is important to that. And those later government actions build on the legal principle announced in Brown. But even in a moment like Cooper v. Aaron, it's not like the court's claim that it is supreme is self-executing. It's dependent on other actors to realize its mandates.
Turning to the role of the court in recent American history, there's a narrative that's emerged in some quarters, I think particularly on the right, but you also hear it on the centre-left, that the Supreme Court has become more powerful as Congress has become more paralysed. So as Congress has stopped being able to do its job, the Supreme Court has come into that power vacuum. My view on this is I think there's an element of truth there. I think it's also far too passive in its description of the court. The court hasn't just happened to pick up power that the legislator has left on the table. The Supreme Court has, to use your word, continued to arrogate power to itself in a number of ways.
I think that's right. I think the court is in an unusually aggressive posture. And putting on my political history hat, I can tell you a story about how the conservative movement in the United States, after failing to achieve its objectives through electoral politics, found ways to try to achieve them through the judiciary. And that, I think, helps explain some of the aggressive posture we're seeing from these judges.
And has been largely successful in many of those objectives in achieving them through the courts.
Incredibly successful, including when they're deeply unpopular, which can explain some of why they've been unable to achieve them through electoral politics. I think the story about Congress, there was a famous book about Congress called The Broken Branch from many years ago. And there are scholars of Congress today who like to push back against that and say, it's much less broken than you think. I would defer to my colleagues who are real experts there. So I think here of somebody like Josh Chaffetz at Georgetown, who you might actually consider having on the podcast. He's really wonderful. He would say a lot of the talk about Congress being dysfunctional is really just from people who are too lazy to understand how Congress works and are carrying a very simplistic understanding of Congress in their heads, and then are frustrated that Congress doesn't actually operate the way that they, in their grand wisdom, think it should. And obviously, no one is more guilty of this than Neil Gorsuch. I was just teaching about this in class, so it's on my mind right now. When people criticize Congress, they're frustrated about the fact that it doesn't push bills through the ordinary legislative process the way it used to, that it tends not to pass bills in response to discrete legislative issues, that staffers are deeply involved in the actual crafting of language, that there isn't high-minded deliberation on the floor of the legislature. But like, so what, man? You know, that's just somebody's grandiose idea about how a legislature should operate. In fact, today, the legislature passes many thousands of pages of legislation every year that is super consequential and has major effects on the economy. They legislate on many issues that are being discussed in the newspapers every day. And even though the deliberations don't happen on the floor of the House, there's a ton of debate and input and horse trading and conversation. It just happens in a more roundabout way. So the leadership exercises a lot more authority than it used to. Committee markups are important, but they can often be performative. The real drafting is happening in dark rooms. Staffers are involved, but staffers are often bringing energy and expertise, and they're always acting pursuant to a mandate from their principal. So they're meant to embody the wills of their principal. It's possible that congressmen don't read all the text of legislation, but frankly, I don't know if you've taken a look at legislation. It's unbelievably hard to read. It's probably a good thing that they're making their decisions on the basis of committee reports and summaries and talking memos that have been introduced by the people who are actually following it, and on and on. And then they pass these large omnibus bills. So to be clear, it's not that there aren't huge problems with the legislative branch in the United States. I think the biggest problems are related in part to the changing media environment, the changing incentives for representatives, and the basic lack of representation, by which I mean that the House members are probably representing way too many people. And because of the way American federalism is embodied in the structure of the legislative branch, the House and Senate are basically anti-democratic. The Senate is just structurally anti-democratic. So in a fundamental way, these two institutions.
I think people don't realize the extent to which, way in excess of, say, the Electoral College or something like
absolutely.
that.
It's utterly indefensible. And all the stories that people have about trying to defend it are, to go back to the word I was using before, they're ideological. They're just made up just so stories to make people feel okay with living with an institution.
Oh, the founders wanted to balance the power of small states. Okay, so what? You know?
Exactly. Yeah, it's right. It's even richer than that. So I mean, we can talk about that too. But basically, you know, my feeling there is that, like, of course, the legislative branch is broken. But the legislative branch has been broken in that way for a very long time, right? Even before the kind of current attack on administration that we're seeing by the courts. So I don't think that's the explanation. So I think you're totally right there. I think what's a maybe more defensible version of the argument you were just making in the standard narrative is that the courts have done a lot of things related to administration that wouldn't be such a big deal if Congress passed laws in response to what the court did. But the laws that the court is undercutting were passed at a different moment in American history, which had its own problems, but in which Congress was much more active in trying to solve some of these problems through law that created administrative agencies. And that now the Congress is in a situation where it is unable to respond as quickly to some of the things the court is doing. And so the court often frames its action as, well, we're respecting Congress here. We're just doing this in the name of asking Congress to speak more clearly or trying to realize Congress's will, when in fact what the court is doing is putting additional burdens on Congress and doing actions that it knows that the legislature is not going to be in a position to respond to because of the new media environment, incentives on Congress people, increasing lack of representativeness of the legislature, and so on.
One addition I'd make to that, not at the level of institutions so much, or even at the level of founding intent, but just at the level of big narratives that we tell ourselves, which is kind of abstract, but also kind of the level that political theory operates at a lot of the time, is the justificatory narratives we have, by which I mean the stories we tell ourselves about how democracy is quote-unquote supposed to work, what we imagine that we're trying to get back to when we talk about politics having gone wrong. Those stories largely don't have political parties in them. The vision of democracy we have is often districts elect their people and they engage in some sort of high-minded debate and good legislation emerges. But that's not how any real representative democracy has ever operated. And that kind of illusory justification impacts separation of powers theory and practice as well, because a lot of how we think about separation of powers imagines that representatives are acting primarily as a member of the Senate or a member of the House, whereas in reality they're mainly acting as a representative of the Republican Party or of the Democratic Party.
You're exactly right. There's a famous article by my colleagues Rick Pildes and Darrell Evanson that I still think is just revolutionary, called Separation of Parties, Not Powers, where they draw attention to this very mistake and point out that the separation of powers, to take us back to the beginning of our conversation, was supposed to be a political technology or tool of institutional design to secure freedom and create efficient government by counterbalancing interests and incentives. That's the classic story. But what that technology missed is that these actors, just as you were saying, are not going to be acting as individuals. They're going to be acting as members of a party, and the party will transform their incentives and their relationship. So to put it in the most like simplistic model terms, the founding father vision would be, well, Congress will be jealous of its prerogatives. And so when the president tries to trench on them, Congress will push back. But Congress is composed of parties. The president is a member of a party. And that will change whether Congress is actually jealous of its prerogatives or not, as we're seeing in the United States right now. So the president of the United States is trenching in all kinds of ways on congressional prerogative, and yet Republicans in Congress are only too happy to go along with it because, in fact, in their calculus, it advances the party's interests, even if it undermines the principle of separation of powers.
Yeah, I tweeted, well, not tweeted because we're all on Blue Sky now, but whatever we call it on Blue Sky, I posted that these people have been saying forever, oh, it's a republic, not a democracy. And it turns out, and it's partly in jest, but partly just what's happening, that what that republic actually means is the executive branch button mashes, and then 1 to 5 years later, the legislative branch decides what they want to keep or not. And we have no legislative branch. That seems to be our governance now.
I like that image. I think what's true, and I've thought about this a bit, although not quite in the terms that you framed it, is that there's been a slow secular movement away from Congress as the site of policymaking toward the executive branch, and now increasingly to the person of the president and the people around him. And that's most clearly embodied in Donald Trump, because Donald Trump is so contemptuous of the rule of law and so idiosyncratic in his preferences, and has illustrated so dramatically how he's able to impose his own personal views on the rest of the party and force them to fall in line, even when they were totally out of keeping with the orthodoxy of the Republicans in the legislature or other Republican Party elites. So this personalization of the presidency and the personalization of American democracy is exactly what seems to be happening. And if you wanted, you could kind of like chart a shift, and you could periodize it from eras in which Congress was more dominant to moments in which the president and Congress seemed to work together to craft policy, and increasingly towards a world in which what American democracy seems to mean is that the people vote for a single leader who rules over them. And then there are various institutions that may or may not try to check them. And I guess you're going to still need to go to Congress to pass a budget. But what I've just described, right, the people vote for a leader to rule over them, who then introduces a budget to the legislature, which they get to vote up or down. That's actually a parliamentary system. That's a prime ministerial system, which is something that reformers at the turn of the 20th century contemplated introducing into the United States. I've written a bit about this, and I just want to give a shout out to Jordan Rudinsky. I served on his dissertation committee. He wrote a wonderful dissertation about this also that tracked some of the ways in which there was this earlier parliamentary fantasy that people were trying to Trojan horse into American democracy, and people resisted it. And nobody resisted it louder than the Republicans. And lo and behold, here they seem to have erected something that even Woodrow Wilson wouldn't have dreamed of.
Well, so this is a bit of a side point, but I did an audio essay some time ago now. This was like Trump 1 presidency, but I sort of think, I got that right. In that my argument was that it's not just institutions, there's political cultures. What do voters think they are doing when they cast a ballot? How do they hold politicians accountable? How do politicians believe that they will be held accountable? And how do they see their role in, praxis, you might call it, right? And what I said is, like, what's weird about the US is we kind of have an increasingly parliamentary praxis trying to force itself through congressional institutions. And if it seems frustrating and kind of nuts, like, that's the contradiction. It's not that either congressional or parliamentary are good or bad. It's that they're not coherent with each other. And we're kind of trying to practice both at once. And that's sort of the fons et origo of a lot of the frustrations and just kind of, frankly, weirdness of American politics right now.
I think that's super insightful. I got to go listen to your audio essay. I think obviously there's some differences that remain, but maybe that's also part of what's pathological. right? One interesting puzzle about the United States is that we're picking this leader of the party through this media environment more even than the particular elections. And then they just run the party. And so it's not like, I mean, you can correct me on UK politics, but my understanding is that in the UK, the party gets to pick its own leader. And there are these internal party caucuses.
Yes, although that's been complicated quite a degree recently. The UK is doing the reverse. We're trying to force a congressional praxis through a parliamentary system, but that's another story.
How fun. But right, so in the United States, and especially with Trump, what we're seeing is these individual charismatic leaders who are then able to sort of seize control of these organizations. There's a book that came out recently called The Hollow Parties that looks a little bit at this kind of question.
So we've talked fun theoretical stuff. I fear we do need to move on to grim applied stuff. Here's the story I have in my head about what's happened to the Supreme Court over the last decade or so. There's a saying, I forget where it's from, but you go bankrupt slowly and then all at once. My feeling is we kind of went from a centre-right court to a far-right court slowly, then all at once. Obviously, going into Trump 1, we had a 4-4 court. It was Gorsuch first, right? And then, okay, that foreclosed the possibility of a liberal court, but it's replacing a conservative with a conservative. Then we had Kavanaugh, which is replacing maybe a more moderate, or like at least a sort of more temperamental, shall we say, conservative with a more party line conservative. Okay, it's pulling us further. But you still, any one conservative can temper down an opinion. And then Ginsburg dies. And I wrote a piece immediately after that saying, this is over. Like, you don't know it yet, and I don't know what the vehicle of it will be, but national abortion rights are over, and a bunch of other things too. And a bunch of people said you're being an alarmist, but I still maintain I got that one pretty much right. And it was just like, to me, it felt like you're getting pulled towards a waterfall, and then just you were suddenly over, and then that was it. Would you want to complicate, challenge, or build on that narrative in any way?
No, I think that's exactly right. I would just want to build on it and deepen it. And you can see that illustrated in the way in which it went from being the Roberts Court to being the Alito Court, right? It's a court that John Roberts has lost control of. When it was a 5-4 court, John Roberts had a ton of power, right? Because a single conservative vote decided which way the court went. So when Kennedy was on it, of course, people were constantly going after him. But once you replace Kennedy with Kavanaugh, you still have this brief moment when Roberts can control the outcome of cases, which means he gets to write all the important cases. He's still writing the important cases, although notably not Dobbs. We'll talk more about that in a second. But now, if he wants to control the writing, he has to make sure he's in the majority. And because he's got 5 colleagues to his right, they get to decide the outcome of the case. And then he has to choose, well, am I going to go into dissent, in which case I further alienate myself from the Republicans who already hate him because of his decision on the Obamacare case, which I continue to find it fascinating. People on the right have disowned John Roberts, despite the fact that John Roberts is undoubtedly the most conservative judge of the 20th and 21st century, with perhaps the exception of the judges he served alongside, right? He's an unbelievably conservative judge. In fact, he's like core to the conservative legal movement. So the idea that this guy is somehow a secret Democratic Party operative is just insane. It shows you how tribal American politics have become and how much the court has become a us versus them kind of place. But anyway, right now, Roberts, if he wants to control the writing, he has to go where his conservative colleagues are leading him rather than lead him. It's clear that Roberts has always wanted to implement the conservative legal movement's plan. He just wanted to do it incrementally and in a way that did not threaten the legitimacy of the institution of the court. And we see that if we look to some of the core Roberts Court opinions. So think about his decision in Citizens United or his decision in Shelby County. Citizens United is the case that struck down campaign finance law and allowed money to come coursing back in huge numbers into American politics. Arguably, it's what gets us to a world now where Elon Musk and Donald Trump can just credibly threaten to primary any member of the Republican Party and so line their votes up, which apparently is what happened to get Hegseth through. I don't know if you saw this. There was some reporting about this recently. It seems like there was Tom Tillis was threatening to vote against Hegseth for Secretary of Defense, and Trump made a veiled threat, not so veiled. He asked who in North Carolina wanted an endorsement to run against Tillis, and that was enough to bring Tillis into line. So that was Citizens United. That was John Roberts striking down Shelby County, the case that famously gutted the Voting Rights Act. But the Shelby County case is interesting because it strikes it down in a devious, roundabout way. Remember earlier I was telling you the court often does things that it claims are about respecting Congress and that Congress could fix if only there were the votes in Congress to do it, knowing full well that Congress is not going to be able to. So the Shelby County case is a great example of that, because the court doesn't strike the whole thing down as unconstitutional. They just strike down one provision on the grounds that, despite having been passed unanimously by Congress, it did not reflect appropriate considered judgment. And the implication was that, of course, Congress could repass the provision, but everybody knew that once the court had struck it down, Congress would refuse to reconsider it because the Republicans would not want to reopen it since it provides an electoral advantage to them. And that is exactly what happened. So that was Roberts' approach. Roberts was sort of lawyerly, incremental movement towards the Reagan era vision. But once he lost control of the court, that fell apart. And that was perhaps most illustrated in Dobbs, where you'll recall that Roberts actually wrote he did not join the lead opinion. So the lead opinion was just a straight up attack on Roe v. Wade to say, let's eliminate the constitutional right to abortion. And Roberts writes this incredible opinion saying, we shouldn't go that far. There's a problem with this specific law in front of us. We can rein it in, which contributes to the death by 1,000 cuts that the right to abortion was already suffering in the United States. But the 5 conservatives to his right said, well, why should we bother doing that? And they just reach for the prize, which had long eluded the conservative legal movement. And because they now had the votes, decided to strike down the right to abortion. So slowly and all at once, that's exactly what happened. Things were moving more slowly in a conservative legal direction. And then once there were the votes, it appears that the veneer of the veneer that we call the rule of law was just dropped in favor of raw, naked assertions of power, which obviously, to go back to something I said a moment ago, is especially uncomfortable to be talking about at this moment, when I think many of us are relying on that veneer that we, that veneer of civilization that we put over, raw barbarity, the rule of law over raw power, to try to keep the United States from descending into something that would be pretty scary and authoritarian.
Let me try out another narrative on you that follows on from what you said, which is that, so here's a narrative I think that you would disagree with based on what I just heard you saying, is I've heard people, particularly on the more conservative side, say we have like a 3-3 court, we have 3 liberals, 3 moderates and 3 conservatives. And it's like, no, we don't. As you say, we have 6 conservatives in which there is agreement on where they want to go. There is perhaps some disagreement on how incremental versus radical do you be, or even just how do you message that? How much do you wrap it up, or how much do you just do it, right? I think what happened is, I think immediately after Dobbs, and to a degree lasting up until the 2018 midterms, there was sort of a bit of a moment of panic in the Republican Party, something of the dog who caught the truck, that like, have we really brought an electoral backlash on ourselves? And what ultimately ended up happening is like a bit, but not so much. Maybe you didn't have quite as good a midterm as you wanted. Certainly when abortion is on the ballot by itself, it wins, but it doesn't seem to be massively. And then, of course, they continue to win in 2024, right? And I think a lot of the more radical and a lot of the more sort of nakedly partisan decisions we've seen from the Supreme Court come as part of a conservative culture that had a moment of, did we go too far there? But the backlash never really came. And so now just feel like that has really just taken the wind out of the sails of the Robert incremental approach of like, the whole point of that is don't trigger a backlash. Turns out people didn't blame the Republican Party too much for it anyway, at least not the Republican Party nominees for Congress or the president, or not to a degree where they still can't win. And now that backlash hasn't happened, we should probably expect the sort of Alito, just do it. The point of gaining power is to use power. We should probably expect that to be the modus operandi from now on. That's my narrative.
So that I confess I'm less sure about. I mean, part of it is that it turns on some empirics that I just don't know the answer to and have a slightly different first cut take on than you do. So, on the question of the backlash to the court's Dobbs ruling, as you pointed out, every time abortion's been on the ballot as a referendum to restore a right to abortion, it seems to have passed. And there have been some shenanigans to try to prevent that from happening. Meanwhile, let's not forget that Trump himself has had to vacillate several times on exactly what his position is on abortion, especially in the lead up to the election. Right? He said he wouldn't sign a national abortion ban, even though we knew that some Republicans were pushing for one. I'm genuinely not sure what his current position is on something like a national.
But that's fine, because the concern isn't that Trump has to talk dog shit. The concern is whether Trump wins the election or not, right?
Right, but the flip side there is that whatever was going on in that election, it clearly wasn't an election about a woman's right to choose. And
Right.
why it was, when Joe Biden was running, it's long been pointed out that Biden is actually not a super credible champion for women's reproductive care. He's said many things that make it seem like he himself is actually uncomfortable with abortion, certainly not a strong messenger for it. Kamala Harris might have been a stronger messenger for it, but for a variety of reasons, that wasn't the main message on her campaign that broke through. And so, there was a lot of polling on this, and I'm not the I'm not the right person to talk about the empirics of what voters went to the polls on. But I don't know how to assess the contribution or not of Dobbs to the election. And I think just to sort of keep things in perspective, right? Donald Trump did not win a majority of the popular vote. This was the closest election in American history, except for 2 or 3 other ones, right? And so, in fact, the fact that Donald Trump won is clear. He won, but the meaning of that win for American political culture and party direction, I think, is pretty unclear, as we're seeing in both the Democratic and Republican parties. Meanwhile, the kinds of issues that are likely to come before the Supreme Court now, I think we're going to see some abortion stuff, although it's going to be I think it's likely to be pretty grim. And so I think the court is going to try to stay far away from it. Writing about whether there's a constitutional right to abortion, that allows Alito to cast himself in this kind of grand posture, writing about theory and rights. What are they going to do when we're talking about the people who are dying because they're not getting access to abortion services, or states trying to send bounty hunters across state line to abduct doctors to bring them across state lines to face prosecution? Those are the kinds of cases that we may start to see. And obviously those cases are going to be cases I'm sure the Supreme Court is going to want to stay very, very far away from, because of the way in which the politics may look different. On the flip side, it seems like the next targets are more about the kind of culture war Christian nationalism, right? Using religious...
No, I agree. I'm not saying abortion specifically. I'm saying correctly or incorrectly, and in some degrees incorrectly, the Republicans have taken the message that the court, not the president, not even Congress, but the court can do unpleasant, radical things, and it will be fine. That the electoral ceiling won't come crashing down on them. Now, those are, as you say, I think those unpleasant, unpopular things probably won't be to do with abortion. They might be to do with a whole range of other things, but they're not. The last bits of restraint are gone.
Yeah. Well, maybe. I mean, I think, just to come back to your point about the lessons people are drawing about this from political strategy, because that to me is also really interesting. That in this moment, right, the Republican relationship to the court is totally fascinating, because on the one hand, the court is probably not as the Donald Trump is contemptuous of the rule of law, and that enables him to act in ways that lawyers on the left and the right would say are illegal, and so would want to rein him in. And the Congress, Republicans in Congress, are clearly okay with Trump acting in this way. And so from that perspective, the Supreme Court is likely to be a restraining influence on Donald Trump, precisely because lawyers continue to share a certain set of norms about what is and isn't acceptable. Witness the resignation just yesterday of the super conservative paid up member of the Federalist Society, Republican to the core, Trump selected head of the U.S. Attorney's Office in the Southern District when the Trump DOJ tried to force her to do something deeply unethical and dismiss the indictment against Eric Adams in what seems like a straight up quid pro quo. So the court is likely to be a restraining or is likely to be in some tension with Donald Trump and as a result with the Republicans in Congress. So that will create some hostility there. On the flip side, Democrats are looking to the courts to be this restraining influence and save them from the terrible things they think Donald Trump is going to do. And so in this moment, it's almost like the court can truly do no wrong, right? At least insofar as the court is advancing conservative policies through the courts, they can be sure that the Dems aren't going to attack them because the Dems are not going to want to run against the courts and further delegitimize the courts when they're counting on the courts for their political security. Meanwhile, the Republicans are going to want to go further than the courts are going because the courts are this restraining force. And so I think the kind of, you're suggesting, wait, no, are we about to see the Supreme Court throw caution to the wind and just like assert raw power like they did in Dobbs? And my reaction is, I don't know, man. Actually, we may see the court go the opposite direction. We may see them be incredibly lawyer-like and careful while continuing to advance hardcore conservative priorities because given what Donald Trump and the Republicans are going to try to do, from the court's perspective, they're going to be going even further, right? It's like, the court is like Reagan era GOP, and Donald Trump is like, I don't even know what, it's like a return to George Wallace, right?
That's exactly vision. What it is.
And so I think that Alito, I don't know, but I think that Kavanaugh, even Clarence Thomas, right? Clarence Thomas believes in the rule of law.
Well, it is interesting that the most Trumpy of the court have not been his appointees. It's Alito, isn't it? Who's the one who hands the flag up.
I think Alito's a real outlier there, right? I think that this is why I reject the 3-3 court idea. It's wrong for so many reasons. But I suspect that there are 9 votes on the court for the idea that a prosecutor owes an independent duty of loyalty to the Constitution. So this is a little bit in the weeds, but Emil Bove, in his letter, he's the number 2 at DOJ, in his letter accepting the resignation of the head of the U.S. Attorney's Office yesterday. Sorry, I'm talking about what happened yesterday. Yesterday was the most dramatic moment in Department of Justice breach of ethics since Nixon, maybe even more so. This is like the Saturday Night Massacre. It is a huge thing that just happened. It is a massive scandal that honestly should bring down the Trump administration. It may or may not, but it really should. In the letter, Emil Bove, the number 2 at DOJ, wrote to the acting head of SDNY dismissing her or accepting her resignation. He's got this line about how she seems to have misunderstood her oath, which requires her to interpret the Constitution as the president does. And I am reasonably confident that while there is a real hard question about the extent to which the president gets to exercise, how the president's discretion over the executive branch is exercised, and the way that the president gets to bind lower level officers in the executive branch, I am pretty sure you've got a 9-0 vote on the Supreme Court even now for the proposition that when line prosecutors swear an oath to uphold the Constitution, it's a personal oath. And that means at a minimum that if the president asks them to do something that's unconstitutional, they can resign. In fact, they're required to. And what happens beyond that, I don't know. Maybe they should be allowed to contest it internally. But it does seem like the Emil Bove letter suggests that the Trump vision is you pawn owe allegiance to the president, not the Constitution. And the 6 conservative judges on the Supreme Court would undoubtedly disagree with that, even though they have this very expansive understanding of presidential power. So that would be a way, I think, of illustrating how even the Trumpiest of the Supreme Court judges would, I think, have some daylight with what we're starting to see happen in the current Trump administration.
Yeah, for sure. I mean, they have limits. I'm not saying there's no limits. I'm saying that they are increasingly arrogating to themselves the legislative power and will continue to do so. And as long as Trump, anyway, we should wrap. Over under on birthright citizenship?
9-0 Supreme Court says birthright citizenship is in the Constitution.
Is it going to end up there? Are they going to hack it all the way up and take a 9-0 loss?
Yes.
I'll go, you get at least a dissent.
I'll take that bet. I bet the Supreme Court goes out of its way to hear the birthright citizen case just so they can write a unanimous opinion. And
do you
lull
think
us
this
all.
is a this is a burnish their own credentials type
Exactly
thing?
right. That's why
I can see that too. I can see that too. But this is a thing, and then the New York Times and the Wash Post go, see, all you liberals were like completely wrong to be crying about the court. These are high-minded scholars,
Exactly
not fucking
right.
Fox News adult freaks.
You got it. That's exactly right. And there are going to be so few layups that I would be surprised if the court resists an opportunity to take one. But if I'm wrong,
I hear that, and that's the rational strategy. But the rationally self-interested strategy has not necessarily been what this Republican Party has done at a lot of points.
You are correct. As we say in the law, the life of the law is not reason, but experience. And, human experience, not exactly a model of rational decision-making.
All right, cool. You've got a hard deadline, so let's cut there. Noah, thank you so much. Real pleasure. You want to let the listeners know anywhere they should follow you, website, Blue Sky, anything like that?
These days, you can find me on Blue Sky at N.A. Rosenblum, at Blue Sky Social, or whatever the complicated tagline is.
Awesome. Thanks so much for your time.
Toby, thank you. Absolute pleasure.